In the pure Maduro board against Guaidó board.
Now, if you can just give us a moment, we'll get ourselves organised. These things are supposed to make our lives easier. Why don't you just start, Mr. Fulton? I'll catch up with...
Could I first just correct a minor error I made at the end of my submissions yesterday? I have referred to an annex to our particulars of claim in which we set out our allegations against the STJ. What I should have referred to was a schedule to our reply. That document's at 224. Rather more substantively, the next topic within the outline I gave your lordships is public policy. And this section in my submission provides the answer to my Lord Legate's observation that his lordship couldn't see how my argument was consistent with the rule of law. And the answer in our respectful submission is that if rule of law comes into play, then it does so at the public policy stage. And so the safety valve of public policy adequately meets any concerns of an English domestic court as to the consequences of giving effect to foreign sovereign acts. And as I emphasised yesterday, there's no actual public policy point in play in this case. And we deal with this as a topic only because it's important to explain how we, in agreement with Lord Sumption, say that the Act of State doctrine operates. And we've obviously been clear throughout the proceedings that the prima facie rule of automatic recognition of sovereign acts can yield to public policy. And we pleaded that at 3.3 of our reply. We said, since such legislative and executive acts of a foreign independent sovereign state do not conflict with any principle of domestic public policy, it follows that the court cannot, as a matter of jurisdiction, alternatively should not, as a matter of judicial abstention, entertain any challenge to their legality. But the Maduro board has never suggested that any such public policy objection to the appointments is open to them. As I showed the court yesterday, their objections are those summarised at paragraph 120 of their case, and they are exclusively points of Venezuelan law. Some of them more technical than others, but nevertheless simply points of alleged Venezuelan illegality. And to state the obvious, domestic illegality cannot, without more, establish a public policy objection, or the exception would consume the rule. And the Maduro board themselves say, in terms, that not all illegal acts are contrary to English public policy. And that's at paragraph 165 of their written case. In the brackets at the bottom of that paragraph, this is page 2112. They correctly state that the public policy exception, by definition, doesn't apply to all illegal foreign executive acts. And although we would suggest that there has been a lack of realism in certain of other submissions of the Maduro board, they have never gone so far as to suggest that it somehow contravenes English public policy for President Guaidó to have sought to safeguard assets from Mr. Maduro and those described by Mr. Maduro, Interim President Guaidó, in correspondence with the Bank of England as being the cronies of Mr. Maduro pending fresh elections. And that would have been a hopeless assertion to say that in any way English public policy was offended by what President Guaidó was seeking to do in relation to these valuable Venezuelan assets. And so within the scheme of the foreign act of state doctrine, we say public policy is absolutely fundamental because a court is never required to give effect to a foreign sovereign act which offends our own domestic public policy. And at root, that is in itself a reflection of the principle of sovereign equality and autonomy, because it means that a foreign state can never dictate by its own state conduct the outcome in our own courts. English law always reserves to itself the ability to say that a foreign law or a foreign executive act shouldn't be recognised here and given effect to for public policy reasons. And so we say that the availability in principle of a public policy override gives coherence and flexibility to the foreign acts of state doctrine. Coherence, because in the absence of any offence to English public policy, there's no reason why an English court should take it upon itself to investigate the exercise of public powers by a foreign state. Our courts say that we will recognise your sovereign acts, lawful or unlawful, we don't mind, insofar as they're consistent with our own public policy. If they're inconsistent, demonstrated to be inconsistent, then we won't recognise them. So it gives that coherence. It also gives flexibility because the public policy response is calibrated to the particular subject matter. And so, for example, governmental acts of racial discrimination fall within the same analytical framework as the withholding of contractual payments to an oil and gas company. But the policy considerations, and hence the court's readiness to recognise the effect of those sovereign acts, will be different. And those are obviously real-world illustrations. That's the case of Oppenheimer and Catamol in relation to Nazi racial discriminatory legislation. The withholding of contractual payments to an oil and gas company was the subject matter of Reliance Industries in India, decision of Mr. Justice Popplewell. And so the framework of what Lord Neuberger described as a hard-edged rule, that's 146 of Belhaj, in combination with a flexible and fact-sensitive public policy exception, also then accommodates the evolving public policy over time. And that's a point specifically emphasised by Lord Sumption at 250 of Belhaj. It's explained by reference to Lord Wilberforce in a case called Blathwayt and Baron Corley, and the same point and the same citation is made by both Lord Nichols and Lord Hope in Kuwait Airways, paragraph 28 and 145 respectively. That's 3882 and 3911 of the bundle. And Kuwait itself is a prime illustration because Iraq's invasion in 1990 provoked an altogether different public policy response than would have been seen in 1936 if the court had then been asked to address equivalent act of state issues following the armed invasion of Abyssinia by Italy. And one can see the shift in attitudes in those 54 years, because in 1936, when Italy invaded Abyssinia, it was afforded by HMG first de facto and then de jure recognition. By contrast, when Iraq invaded Kuwait, it was universally condemned, and HMG stated categorically, in a conscious departure from its 1980 policy, that it did not recognise Iraq's occupation, and Iraq wasn't to be treated as any sort of de facto government of the occupied Kuwait. And so public policy is what enables the court to give legal effect to conduct, to decline to give legal effect to conduct associated with gross breaches of international law or racial discrimination or acts of torture and injury to the person. And so in that context, it was addressed specifically in Belhaj by Lord Neuberger in paragraphs 153 to 156, in a lengthy section of Lord Sumption from 249 to 268. And what Lord Sumption has to say about public policy is absolutely fundamental to our argument, because that passage is the counterbalance to the first part of his analysis, which concludes with the propositions which I've already taken your lordship to, that prima facie, the court doesn't investigate the legality of foreign sovereign acts, and the act of state doctrine applies even in relation to executive acts which are unlawful by their own law. But he doesn't stop there. That's not a complete reflection of the rule. He goes on to say that this has to yield then to public policy, and then he sets out a very detailed analysis of how that operates, including, importantly, by reference to international norms and the relationship between English domestic law and international law. And Lord Mance also saw the need to take into account policy considerations on a case-by-case basis. And although he did express reservations about Lord Sumption's approach of rooting this in international norms, that's paragraph 107 of Belhage 2346. But we would respectfully submit that it's the analysis of Lord Sumption on this which is to be preferred. And the Maduro board's submission is essentially that there's a slippery slope between an English court giving effect in this case to the allegedly unlawful appointments that Mr. Guaidó has made and giving a free pass to Hitler. And your lordships may have heard of Godwin's law, which states that the longer an online discussion continues, the probability of one of its contributors drawing a comparison to Hitler and the Nazis approaches 1. And there's something slightly similar going on in the Maduro board submission at 2111. One sees at paragraph 63 the reference to the US case of Bernstein. And this is used to support a submission that the English court should not embrace a second rule insofar as it relates to unlawful executive acts, because one goes down this dangerous path of potentially having to recognise the conduct of a Nazi or Nazi-style regime. And in fairness to the Maduro board, they do say at 165 that it might be said that an English court in the same position would have applied a public policy exception to get the right result. Well, of course, the English court would. And we know that from Lord Cross in Oppenheimer and Catamol, which was then embraced and applied as a correct statement of the principle in Kuwait Airways and Belhage to enable those allegations of wrongdoing to proceed. But whereas the Maduro board say that to invoke a public policy exception in these circumstances is to miss the point, with respect, it's they who are missing the point. Because they say it's not the business of the UK's legal system to enforce domestically illegal foreign executive acts. But the true proposition is it's not the business of the UK's legal system to conduct an investigation into whether a foreign executive has exceeded its powers. And the proper ambit of judicial review of our own executive is a controversial enough topic in this country without taking on the burden of acting as an external judicial review body for the executive action of foreign states within their own countries. And what the Maduro board's Bernstein submission also overlooks is that it wouldn't make the conduct any more acceptable to English public policy if it happened to have been lawful under Nazi law. The public policy inquiry looks at the purpose or effect of an act of state, not its domestic legality. And so it won't save the conduct from a public policy objection if it is done lawfully under the foreign law, but nor does the mere fact of unlawfulness engage the exception. And that then creates a consistency of approach between the general rule and the exception, because the outcome of neither is dictated by the domestic lawfulness under foreign law. And that certainly does not mean that the court can never, as part of a public policy inquiry, have regard to the decisions of a foreign court or to the wider rule of law considerations which my Lord Legate raised. And there are at least two contexts in which such decisions may be relevant. Firstly, if the reasons why a foreign court has ruled something unlawful coincide with considerations of our domestic public policy, such as breaches of international law, other fundamental rule of law considerations, or the gross violation of human rights, then that is likely to fortify the court in the application of a public policy exception. And so respectful regard can be had to those foreign decisions if, but only if, a public policy exception is sought to be relied upon, because without reliance upon the public policy exception, it's the general rule which prevails, which is that the court just simply isn't interested to know what the domestic legal position is and not interested to know what any foreign court has had to say on the topic. And by fundamental rule of law, I obviously don't mean some trivial technical oversight. And the English common law is not so blunt an instrument that it can't distinguish between Nazi atrocities and the pink versus blue paper example I gave yesterday. But the only way of discriminating between those different types of foreign illegality is by treating the act as prima facie caught by the principle, the act of state doctrine, and then at the second stage, if it arises and if it's invoked, by the court asking itself whether there is an overriding public policy reason not to give effect to the sovereign act. And so in that respect, it may well be relevant for an English court to pay careful consideration to the decisions of a foreign court, only, however, if a public policy exception is engaged. In another aspect in which the decisions of a foreign court may be relevant is that if a foreign government or president of the foreign state is choosing to defy the decisions of their own court, then any reasons relied upon for doing so may be of the utmost relevance, or indeed the absence of any such reasons may be of the utmost relevance to the court's public policy inquiry. The court may be interested to know, as a matter of public policy, why it is that a government isn't acting in accordance with what its own Supreme Court has said. And so a president who ignores the rulings of his own Supreme Court for a manifestly bad reason, or for no reason at all, may well find it difficult to resist the public policy objection, particularly if his actions appear to be motivated by some personal benefit. And that's an illustration, a hypothetical illustration, which is given by the House of Lords in a case called Civil Air Transport, Privy Council, I beg your pardon. This is at 3324. And this was to do with the recognition of governmental acts where there had been a change of government. And then 5 lines down, at the same time, the Lordships mustn't be understood to reject the possibility of our courts refusing, in a conceivable case, to recognise the validity of the disposal of state property by a government on the eve of its fall, for instance by a despot who knows that previous recognition is just being withdrawn, where it is clear that his purpose was to abscond with the proceeds or to make away with state assets for a private purpose. But by contrast, if such a person has an apparently credible explanation for acting in defiance of the decisions of a domestic court, such as here to safeguard the assets of the country from a kleptocratic regime, then that may be sufficient to neutralise any public policy objection, even without the court having to determine the status of those foreign judicial decisions. But critically, it is for the party invoking the public policy exception to establish that it applies, which is what the Maduro board has never sought to do. So none of this arises because a policy point hasn't been taken. But since the Maduro board say that our argument as to the general rule leads to absurdity and injustice, it's useful for us to show why that's not so.
So I can understand the logic of your argument, Mr. Fulton. To take an example where, say, the President of the United States makes an executive order which is declared unconstitutional by the US Supreme Court because it's not within the President's executive powers under the Constitution. Your submission, I think, is that the English court should treat the executive order as lawful and valid, notwithstanding the US Supreme Court decision, unless, on embarking in an investigation into public policy, one can find that the reasons why it was declared unconstitutional are sufficiently egregious in public policy terms, but otherwise the US Supreme Court decision is ignored.
My Lord, that's exactly my solution.
What possible basis is there in principle for, I mean, why does that give respect to the sovereignty and autonomy of the United States, simply to disregard its constitutional structure in that way?
Because so far as outwardly, the sovereignty is expressed through the executive. And obviously, in my Lord's example, quite apart from the judicial consideration, if that sort of thing was going on, one would expect that to have prompted some pretty significant diplomatic engagement. And we say that first and foremost, because of the separation of powers, if a foreign president, such as the President of the United States, was acting in that way, acting in a way which the Supreme Court of his own country had declared to be unconstitutional, then the first engagement is by our executive, by the Foreign Secretary, on the diplomatic and international plane, to say, well, we're really very concerned about this in terms of the interaction between states. We, the UK, don't like the fact that you, a foreign president, are inviting this court, or your appointees, or those successors in title, or someone who's been affected by that conduct, are inviting our domestic courts to give effect to acts which we know and we have seen that your own Supreme Court has declared to be unlawful. So the primary engagement in that example, we would say, would be on the diplomatic plane. It's not the concern of the English domestic courts. And if it couldn't be resolved on that basis, and the US president was nevertheless insisting, or those claiming under the US president were insisting that his acts should be treated as valid, then first and foremost, yes, my Lord, we say that it's his executive acts as sovereign acts, acta jure imperii, which are to be given effect to whether lawful or unlawful, we say that would require, at the first stage, for the English court to put to one side the Supreme Court decisions, because the Supreme Court decisions aren't relevant to whether or not the act of state doctrine is engaged. Then, at the second stage, if a public policy objection is invoked, then, obviously, the court can have regard to whether what the US president is seeking to do offends our English public policy. And that would be a fact-sensitive inquiry, depending upon the nature of the act and whether English public policy could be said to be offended by it. English public policy in that context also encompassing...
Well, why do you ignore the constitutional arrangements of other states in that way and, in effect, treat every executive as though they're a dictator?
Because it is not for the English court to inquire into those constitutional arrangements. Every country will have their own constitutional arrangements, and it is not the role of the English court to scrutinise those in order to form a view as to the validity or constitutionality of steps which the foreign executive has taken. Any consequences of acting unconstitutionally will be a matter for the foreign state. And so if the Supreme Court, having ruled the US President's Executive Act to be unlawful, then seeks to restrain him, if that's a power that's available to the US Supreme Court, then that's potentially a separate question. But the question of well,
that's quite difficult for you to say. What's the difference between the court seeking to restrain him and declaring that what he's done is invalid legally?
Well, because, my Lord, the declaration of the legal position is a declaration as to the foreign law.
Well, so is a restraining order. Well, that's an order of foreign law.
Well, but that's
and he can simply disregard it, as far as we're concerned, on your principle.
That's coercive. I mean, if there's an order of the foreign court which is sought to restrain something, sought to have a tangible impact, rather than simply what declaring a foreign law is, and by whatever route a party was seeking to say that this court, the English court, should have regard to an injunction which had been granted and directly recognise or grant an equivalent injunction to prevent it, then obviously that in that context the court would need to consider, within the framework of recognition of it and enforcement of foreign judicial decisions, whether or not there should be relief granted. We're not in that territory. What we're talking about is the declaration of the foreign law, and our primary position, or our position, is that because the Sovereign Act isn't proved, its status doesn't depend upon its domestic legality, it's not a relevant consideration to the engagement of the Act of State doctrine, the fact that a foreign court may have declared it unlawful. because it exists on its own sovereign plane as a matter of international law, as we saw from the ICJ yesterday. Acta jure imperii are still acta jure imperii, even if they are admitted to be unlawful, because their status as sovereign acts does not depend upon their domestic legality. And so that's why at the first stage it's not only appropriate but necessary for the English court to put to one side anything that the foreign courts have said on the subject.
But I don't think that follows, though I can understand your principle that the English court shouldn't decide for themselves questions of lawfulness,
Yes.
of foreign legality. But it's a further step in your argument to say that the English court should also ignore a decision of the foreign constitutional court.
My Lord, yes.
That doesn't follow from the fact that we shouldn't decide questions of foreign law.
Well,
we're not. We're simply giving effect to what the foreign constitutional court has decided.
My Lord, yes.
And normally we recognise foreign judgments as binding,
Yes, yes, my Lord.
unless they're contrary to public policy.
Yes, yes, my Lord. The issue is what the court is interested to know in terms of the content of the foreign decision, and in circumstances where it is not interested to know, it's not a relevant question as to the status of the executive act, as to whether it's unlawful or lawful under its own law. Then it's on that principle that we say the court ignores it. The underlying reason, my Lord, for the English court declining to enter this arena is not, my Lord, it's not an allocation of jurisdiction. This is not a forum convenient situation or situation where it is that one court has exclusive jurisdiction to determine those, so the English court doesn't entertain it, but then will abide by the outcome decided in the appropriate court. It's more fundamental than that, because it's that the English court just simply isn't interested. Because the reason it's not interested is because the status of the act, as a sovereign act, does not depend upon its status under the foreign law or its constitutionality or whatever the foreign state has done in terms of organising its affairs. Internally, that's entirely a matter for the foreign state. And we say that's just simply the position at which the English common law has adopted in relation to this, to say, well, those are your affairs. That's why it's expressed in terms of not asserting the UK's jurisdiction over the internal affairs of a foreign state, because that's a matter for it. And if, as I say, if that causes a tension or a conflict between branches of the state, then they need to be worked out domestically within the foreign state, rather than for the English court to say, well, yes, I see what your Supreme Court has said, and we're going to recognise that and therefore treat your executive act as invalid. And the great benefit of the process of dealing with it at the public policy stage is that it can encompass all considerations. If there were an executive act of a foreign president which had been undertaken unconstitutionally and in breach of his own laws, but for some absolutely overwhelming humanitarian emergency, and decided that action needed to be taken, there weren't yet the laws enacted to enable him to do what he needed to do, but he decided that was appropriate. And so he acted deliberately and knowingly unlawfully, but in a way which cried out for humanitarian action, then we would say, well, of course the English court should give effect to that, notwithstanding that the Supreme Court has said that technically it's unlawful.
And are you going to show us any authority for that, or is it simply a matter of principle as far as your submissions are concerned?
I can't show you, Lordship, any authority where there has been an adverse foreign decision that has ruled the Executive Act unlawful. But what our submission depends upon is what we say is the inexorable logic of the Lord Sumption approach, which I'll take your Lordships through, which is that it doesn't matter to the English court whether they're lawful or unlawful, and it has to follow. We say it is the inexorable logic of that submission that it can't matter what the foreign court has held, because the question of legality is not the criterion for the status of the act before an English court. The criterion for the status of the act before an English court, prima facie, is that it's a sovereign act to which respect will be given as a basis of sovereign equality, and that will be treated as valid. subject to the ability for someone who objects to that being given effect to say, well, no, this is contrary to public policy, you shouldn't give effect to this. And so the supposed Bernstein injustice of that sort of conduct, we say doesn't arise because of the public policy safety valve. If, on the other hand, the supposed injustice relied upon by the Maduro board is the so-called loss to Venezuela of $2 billion or so of assets, which is what they say at 1162 of their case at 2096, then that's obviously a false point also, because there's no such loss. These assets aren't being lost to the BCV. Mr. Justice Tier was careful to emphasise that title remained throughout with the BCV. This is not the civil air transport hypothetical example where a despot seeks to plunder state assets for his own use. That could have been a highly relevant scenario if Mr. Maduro, within the 8 days he was given as an ultimatum to call fresh elections, knowing that HMG had said, if you don't do so, then we'll recognise Mr. Guaidó. If he'd taken that opportunity within those 8 days to take steps and make appointments with a view to plundering BCV assets, then the court could have said, well, no, that's contrary to public policy. They remain acts of state at that stage. They remain acts of state because at that stage Mr. Maduro was still to be regarded as the president. But the court plainly wouldn't have been obliged to give effect to those sorts of corrupt activities. And indeed, leaving aside the egregious case of corrupt associates having been appointed to facilitate the theft of state assets, it's not easy to see how English public policy would even be interested in who happens to be put in charge of a foreign central bank. And so, turning it round, if a foreign court were applying an equivalent act of state doctrine and a disaffected Mark Carney was trying to complain to the foreign court that the correct process hadn't been followed in relation to his replacement by Andrew Bailey, the foreign court wouldn't be interested. They would say it's not a matter of public policy for us. It's a matter for you, the Bank of England and the government, to sort out that appointment. And if it's been done unlawfully, then you'll have to straighten that out. But we're going to treat that as a valid appointment because it's not our business to inquire as to whether these steps have been taken lawfully as a matter of English domestic law. And certainly in cases of state acquisition of private property, English law has consistently taken the view that all of that is entirely a matter for the foreign state operating its own economic policies, whether or not we agree with them in this country. The state takes assets into its ownership by an act of expropriation. The English court then treats that expropriation as valid to transfer title. And it's only where there's something specifically objectionable about the acquisition, such as the moral repugnancy of the Nazi legislation or Iraq's use of force in breach of international law in Kuwait Airways, that public policy considerations are engaged. And if an English court must decline to adjudicate on the legality of a foreign expropriation, including, as we see from Williams and Humbert, of the shares in a foreign company which indirectly owns English assets, then it's entirely unprincipled in our submission to hold that a change of control by the appointment of a new board can be held up to any greater scrutiny. And so the theoretical possibility, which doesn't arise on our facts, of an English court being persuaded of a public policy imperative to decline to recognise a foreign sovereign act is absolutely fundamental. And it doesn't mean that the doctrine collapses into uncertainty any more than in any other context where public policy is capable of disapplying a general rule. A contractual bargain governed by English law will generally be enforced unless contrary to public policy. Likewise, an arbitration award or a foreign judgment, as Lord Legate points out. Ordinary choice of law rules can be overridden if the application of a foreign law would be contrary to public policy. And that's a perfectly workable and coherent scheme. And it's precisely the scheme of the Act of State doctrine outlined by Lord Sumption in Belhage. And what it means in practice is that the court focuses upon the Executive Act and whether to treat it as valid and effective would be contrary to English public policy. And there are various grounds already recognised in the jurisprudence. I've mentioned racially discriminatory legislation, Oppenheimer and Catamol. I've mentioned gross breach of international law, Kuwait Airways, acts of torture and rendition, as in Belhage. And these aren't closed categories. and the policy considerations are to be judged against contemporary and changing standards. But illegality without more is not enough, because that would then open the door for illegality on some technical and trivial basis, the blue and pink paper example. And a finding of illegality by a foreign court isn't enough either, because foreign judgments sit on a different and lower plane to the executive and legislative acts, see UKOS, and are not automatically recognised and enforced unless under a treaty or convention which provides for that. But nevertheless, a flagrant disregard of the rule of law could well come into play if it were thought by an English court to contravene public policy, rather than simply be some technical infringement of the local law. And an obvious example of that, my lords, would be corruption, given that UK's status as a signatory to the UN Convention on Anti-Corruption, which explicitly recognises the need for a coordinated international response to the problem of corruption. And so we again embrace here what Lord Sumption says from 249 and following, where he roots these considerations in Jus Cogens and the relationship between domestic policy and international norms, and very much in line with what the Court of Appeal said about this in Belhage at 115. That's at 2264 of the bundle. And that refers to the fundamental change having occurred within public international law. And these changes have been reflected in a growing willingness on the part of the courts in this jurisdiction to address and investigate the conduct of foreign states and issues of public international law when appropriate. So the courts have already said that there is scope for the investigation of the conduct of foreign state actors, but it does so under the umbrella of a public policy objection, which disapplies the act of state doctrine and enables the court to have regard to the nature of the conduct, the nature of the effect on those who are impacted by that conduct, and to see whether, in fact, an English public policy exception is engaged.
Mr. Fulton, one of the threads that runs through some of these difficult cases is that courts in this jurisdiction should not be sitting in judgment on executive acts of sovereign acts of foreign governments.
Yes.
And we get that classically in Underhill and Hernandez, yes, where Duke of Brunswick and King of Hanover is taken up in the United States. But where there's a judgment of the foreign court,
yes,
the English court would not be sitting in judgment.
Well, that was the Court of Appeal's reasoning, yes. But we respectfully disagree. We say that in circumstances where the decision of the foreign court is being prayed in aid in order to say here in this court and to invite this court to find that the actions are ineffective or unlawful, then that is sitting in judgment. The Maduro board wanted judgment from the English court saying that President Guaidó has failed to make the appointments which he believes he has made. And so it's at one level of remove because the argument is premised, or the argument relies upon the findings of the STJ, but it's no less sitting in judgment for an English court to say, I'm terribly sorry, foreign president, you haven't made these appointments. We've concluded that these are unlawful. There's no less sitting in judgment merely because that decision is in turn based upon foreign judicial decisions.
It's rather different from a court in this jurisdiction itself taking it upon itself to consider the detailed arguments of constitutionality within Venezuela.
It is different. It is different, but this is to pick up on my response to Lord Legate. The issue here is not allocation of jurisdiction, as in which court is most appropriate to decide something, and therefore an English court will stay its hand, it will not intervene, and it will wait until a more appropriate court has decided the question. It's nothing to do with forum convenience. It's a much more fundamental constitutional point that it's not the function of the English court, based upon our allocation of constitutional responsibility, to investigate the legality of or to make rulings on the legality of the acts of a foreign sovereign, even though in doing so it has the benefit, or the perceived benefit, of a foreign judicial decision. And that comes back to my prior point, which is that the status of those sovereign acts isn't proved by and doesn't depend upon their domestic legality. Their status is determined by their sovereign status, because they're sovereign acts, which remain sovereign acts, even if they're domestically unlawful.
I can see that it's nothing to do with allocation of jurisdiction. But what is suggested to be objectionable here is the interference by the courts of one jurisdiction in what are regarded as internal matters of another state.
Yes. But we say
that element is not present, at least to the same extent, in a situation where there is already a judgment of a court of the foreign state dealing with precisely the point.
My lord, it arises in a different way, but it's nevertheless, we say, still interference in the internal affairs of Venezuela, because it is then saying to the recognised president, you haven't made these appointments properly. And the reason it's saying that is because the foreign court has said so. But that's still an interference. It's just that the argument being run, it's no different, my lord. Fundamentally, we say that the argument is no different merely by reference to the fact that there happen to be these foreign judicial decisions. Before those decisions came, the Maduro board would still have said, their position would still have been that the Guaidó appointments are unlawful. They have the benefit of a decision, which we say has been corruptly procured, but they have a benefit of a decision.
That's a different point. That may have to be addressed at a different stage.
But we say it's the same argument which they're running. They're saying you, interim President Guaidó, have not made these appointments because they're unlawful as a matter of Venezuelan law. It just so happens that their evidence in support of that is not in the form of an expert report, although there is also an expert report, but they rely not just on an expert report, they rely upon foreign judicial decisions which say so. But it's the same argument that's being run. It's the same attack on legality. It's just being bolstered by reference to a judicial decision. But if it wouldn't be relevant for the English court to inquire as to the domestic legality in the absence of a judicial decision, it doesn't make it relevant because there is a judicial decision. And I understand the riposte to that, which was the riposte of the Court of Appeal and the Lord Legate yesterday, saying, well, this is another arm of the foreign state which has said this. And why should we allow the Executive Act to trump the act of the judiciary? But we say that's the wrong question to ask, because once one characterises the act as being an act in the exercise of sovereign authority, it has its own status, which doesn't depend upon the foreign domestic legality. And all the foreign decision tells you, in this context, is the content of foreign law. But if the English court isn't needing to apply the foreign law, because under our Act of State doctrine, it's not the foreign law which determines the status of the act, then the English court just puts the judicial decision to one side.
But it may be necessary to ask why we adopt that approach, and why this respect is accorded to sovereign executive acts, and the rationale for that, or one rationale for that, may be that it's not the business of courts in this jurisdiction to be investigating such matters, but that falls away when you have a decision of the court of the state concerned.
Well, that would be an argument based upon the allocation of jurisdiction, if that were the rationale. And that's not the rationale with respect for the Act of State doctrine. It has its roots in the sovereign equality of states, and then, as Lord Sumption emphasises at 225, in the separation of powers.
Indeed, and the fact that the proposition that one state should not be interfering with the internal domestic affairs of another state.
Right, and we respectfully suggest that embraces a situation where an English court is being asked to say that a foreign president has acted unlawfully.
And what I'm suggesting is, and it's just a suggestion, because this is not straightforward, is that particular rationale may fall away or may at least be diminished in this situation that we've got.
It's a different factual situation. It's a different factual scenario which hasn't been engaged with by the decisions previously, which in some ways is unsurprising, because if you're applying the Act of State doctrine and you're not interested to ask whether the act is lawful, then the English court doesn't conduct the inquiry in terms of whether or not something's lawful. It won't gather any evidence. And so these propositions have been made in a more abstract way of saying, well, that's just an area of inquiry which the English court won't go into. But we do say that it is a short step from that proposition that the question of domestic lawfulness is irrelevant to then the requirement for the English court to put to one side the judgment which says anything about the lawfulness, because it's just not relevant. It just doesn't arise, because the acts have their own special status, which arises out of their characterization as sovereign acts. And this is why we say it's not out of disrespect, it's not anticipating any arguments which have yet to be proved in relation to why this tension between the executive and the judiciary has come about. It's because the act of recognition of a foreign president carries with it the obligation of an English court to respect his acts in the exercise of sovereign authority. And if that causes a difficulty, because he's acting in a way which the UK disapproves of, then under the separation of powers, that's first and foremost a matter for the executive to engage with and saying, listen, either you need to stop this or we'll cease to recognise you.
I'm not suggesting that's not the rule, but the question may be whether the rationale of the rule extends to the present situation, or to put it another way, whether there should be acknowledged to be an exception.
Well, yes, I follow that.
Circumstances
yes,
that we have.
Yes. We say it's the logic of the rule extends to this case. It's the underlying inexorable logic of it, whereby domestic illegality is relevant, necessarily means you put to one side the foreign decisions.
Can I just test the narrowness of the proposition? Here we have an appointment of the chair of the central bank or director of the central bank made directly by Mr. Guaidó, and so you can say that's a sovereign act.
Yes.
Just say that Mr. Guaidó had appointed the Prime Minister, and the Prime Minister had then appointed the director of the central bank. And the argument was that actually, under the Constitution, the director of the bank has to be appointed by the finance minister rather than the Prime Minister. Then your argument wouldn't apply, because the relevant appointment wouldn't be a sovereign act. So
I can see the argument. That may be much more difficult to establish. If there is some form of delegated authority under the Constitution, so you're not dealing with a foreign sovereign, and a president for these purposes is in the same position as a king or queen, that they are the personification of the state itself. And so that if one's dealing with delegated functions within a government hierarchy, then one can certainly see the argument that the court isn't then in the position of having to simply accept that as valid and effective, because there may be more debate. I haven't thought that through in detail, but I can certainly see the argument.
Yeah. Okay.
But the decision ultimately rests with the English court to address the infringement of public policy, and so it is never open to the foreign court, however esteemed and elevated, to dictate the outcome. And so, for instance, a ruling that indefinite detention was lawful, plainly, an English court in the face of a ruling of that kind will be entitled to say, well, that may be what the foreign court says, but we're not having a bar of that. That's contrary to our own conception of public policy and liberty of the subject. And indeed, we would respectfully suggest that if your lordships were minded to undertake any tidying up of the jurisprudence, then of the two possible routes to the identical outcome in Belhage, then it's the public policy analysis which is to be preferred. And the issue in Belhage was whether the Act of State doctrine was a bar to claims based on allegedly unlawful conduct, which had caused physical and mental injury. And Lord Newburgh expressed his overall conclusion at paragraph 169, which is at 2361. He notes that the third rule, the international law rule, doesn't apply. And then third line down, as to the second rule, I consider that it cannot be relied upon, the second rule being executive acts. It cannot be relied upon because one, Little Roman 1, the alleged wrongdoing involves harm to individuals and not property, and 2, the public policy exception would apply anyway, as it would in relation to the third rule. So he gives 2 independent reasons, closely related, for reaching that outcome as to why act of state wasn't a bar to the claims in that case. The first is that the act of state doctrine doesn't in principle apply to acts which are unlawful under their own law and which cause physical or mental injury. The second basis, though, is that the public policy exception would apply in order to enable those claims to be investigated. And of those 2...
This was a case involving not property, but the unlawful detention.
Sorry, what I missed first.
Underhill and Hernandez was a case which involved not property, but the unlawful detention of the manager of the waterworks.
Yes, my lord. Yes, which is why I'll come to this, but this is why we say the more coherent scheme of the doctrine is the Lord Sumption one, to say that the way you approach it is that all acts within the territory executed by a foreign sovereign in relation to persons or property situated there are prima facie caught by the doctrine. So you have a broad conception of the rule, and then the safety valve of public policy available in all cases, which, as I submitted yesterday, is more or less sensitive to the particular conduct, depending upon what considerations are engaged. And obviously, as one sees in Belhage, conduct which results in physical or mental injury, unlawful detention, that is in effect going to fall within a standing public policy exception, that these are acts which will always be regarded as unacceptable. An act of torture will always be regarded as unacceptable. So for practical purposes, it doesn't make any difference whether you treat it, the general rule as being carved out, or whether you treat it as falling within a permanent exception. But conceptually, we suggest it's much more coherent to take the latter approach and deal with it as falling within the exception, because then one can have a consistency that embraces both acts of torture and rendition, as in Belhage, but it's the same conceptual framework which one applies to the presidential appointments of officials over the central bank. And there has to be a logic in that consistency. And that's why we began the submissions yesterday by referring to Lord Sumption, where he says what promotes the coherence of the law is to try and to identify principles of general application rather than individual rules which apply to specific factual scenarios. And so it's a minor, it doesn't in any way involve disrupting the ratio of Belhage. It's simply to say that of the 2 reasons that Lord Neuberger gave, it's the second reason which is to be preferred. And one can see that also from 160, 2359. Assuming the second rule can apply to executive acts in relation to property which are unlawful, I'm convinced that it would apply in a case such as the act resulting in injuries to the person. He goes on to explain why, and he basically says that none of the practical considerations, the principled and pragmatic arguments for applying a rule in relation to property apply in relation to claims in relation to personal injury. And so there, the distinction that he's drawing in order to carve out personal injury from the rule, they're policy-driven, fundamentally, and so hence it's entirely appropriate, we say, to prefer the second route, the public policy exception, to the Little Roman 1 reason in 169.
Just going back to property, suppose the head of state of a foreign country transfers state assets to associates or friends, and the courts of that country find those transfers were unlawful and void. There then comes a question in this country as to whether to recognise the ownership of those assets. You say we shouldn't just follow the court's decision that they are void, the transfers. We should conduct an investigation of our own into the circumstances of the transfers and decide whether they're sufficiently unacceptable to infringe the public policy requirement or not. And if not, we recognise them as valid despite what the local court has decided.
With respect on those facts, no, we would say that in circumstances where someone would be seeking to justify the conduct of the foreign executive through some nepotistic, some kleptocratic endeavour, then they would simply be unable to do so. Not only because the courts had held it to be void, but there was no underlying rationale to disapply the court's analysis. There would just be no basis to say, by those claiming under the foreign executive, to say that that's an act to which respect should be given.
Well, why not? I mean, I thought the whole point was we don't inquire into whether there's any lawful basis or not. Not
in relation to whether the doctrine is engaged. So prima facie, those kleptocratic appropriations would be an act of state. But this then on the public policy inquiry would be someone saying, well, that may have been an act of state. That may have been the despot in the civil air transport example, and so he's abusing the official powers and position of influence that he has, and so that someone is objecting to that and saying regard shouldn't be had to that in a foreign court, and anyone claiming under him would have no basis to justify the conduct.
Well, the facts might be contested.
Well, if they are contested, then. Then we would submit that the prima facie rule, the act of state principle, is engaged, but it's readily disapplied on those facts, and anyone claiming under the foreign president who nicked the assets would be in no position to demonstrate their legality. And there the rule of law principle.
He wouldn't have to. It would be the other way around, according to you. The burden would be on the person who alleges that there was a breach of public policy. It's contrary to public policy.
Yes,
you'd start off with the presumption of legality.
Exactly. You start off with the presumption.
The local court decision is ignored.
Yes. So the friend of the president is sitting on his assets, which had been unlawfully, or they had been stolen by the president. Allegedly stolen by the president.
The local court has found that, but you ignore its decision because you take no notice of that in this context.
Well, Lord, you ignore it in deciding whether or not the act of state doctrine is engaged. You don't ignore it at the public policy stage. This is my submission that to establish whether they're acts of state, which are prima facie the court shouldn't investigate, you say, right, well, that's a foreign president. I don't know whether that money which he gave to his brother-in-law was in fact for genuine state purposes or whether that was just plundering state assets. And I won't investigate that. That's an act of state. He can do as he pleases with within his own territory, unless someone is saying, well, you shouldn't have regard to those foreign sovereign acts because they are contrary to some public policy. And if it had already been found that he was acting corruptly by the foreign court, then that's going to be a jolly good basis for the English court to say that's contrary to public policy. We won't give effect to that. But you wouldn't need the foreign decision. You could prove it by underlying facts, or you could rely upon what the foreign courts had found about it. But my point is simply that all of this only comes into play at the second level inquiry when one's in the territory of public policy, not in the question of whether or not it's to be treated as an act of state.
Yeah.
And so Lord Neuberger at 160 had said that essentially the arguments that he had identified in relation to property don't apply in relation to persons, and that was justification for his Little Roman 1. And he also said at 162, again showing that effectively Little Roman 1 was policy driven, and so we can embrace it all within Little Roman 2. He said at 162, in a case where neither the first nor the third rule apply, it seems to me that there is force in the point that as a matter of elementary justice, if a member of the executive or a foreign state injures a claimant physically in the territory of that state and the injury wasn't authorised, a third party who's properly sued in this country should not normally be allowed to rely on the doctrine as a defence. So entirely policy-driven, elementary justice. And that we say is the scheme of this. And Baroness Hale and Lord Clark agreed with the conclusions of Lord Neuberger in just a short one-paragraph judgment, and obviously his conclusions encompass those two routes. And Lord Sumption has been very clear in his view that the general rule was applicable to sovereign acts generally and then tempered by reference to public policy. And so we say, we respectfully suggest that the more coherent rationalisation of some of the difficulties which have been thrown out by Belhage and the uncertainties are resolved to a large extent by adopting the second of the two routes of treating this as a public policy exception to a wide general rule. So that was all I had to say on public policy. The next chapter was authorities on our appeal. Given our reliance upon Lord Sumption and the reluctance of the Court of Appeal to adopt his analysis, I was proposing to start with the two English authorities he relies upon at 230 of his judgment, where he says it's clearly established that the Act of State doctrine applies to expropriations with no legal basis at all. And if we could just look at what Lord Sumption says, first of all, at 2388. Paragraph 230. Thus, it's well established that municipal law Act of State applies not just to legislative expropriations of property, but to expropriations by executive acts with no basis at all. He cites Duke of Brunswick and Princess Paley and the American cases and says these transactions are recognised in England not because they're valid by the relevant foreign law, but because they're acts of state which an English court cannot question. And the Maduro Board's submission is that Duke of Brunswick, which is one of the cases cited there, was only a sovereign immunity case. And we say that's in direct contradiction not only to what Lord Sumption says, dealing with it as an authority in support of the Act of State principle, but also Lord Wilberforce. And he said at page 3273, in the middle of the page, more clearly as a recognition of a general principle as Duke of Brunswick, a case in this House which is still authoritative and which has influenced the law both here and overseas. There are two elements in the case, not always clearly separated, that of sovereign immunity ratione personae and that of immunity from jurisdiction ratione materiae. It's the second that I find relevant. And Lord Neuberger also didn't treat Duke of Brunswick as a sovereign immunity case either, but he explicitly referred to it as a decision which was relevant to both the first and the second rules of the Act of State doctrine. Don't need to look at it, but that's at 125 and 138, pages 2351 and 2354. And it's consistent also with the judgment of the Court of Appeal in Belhage, principally drafted by Lord Lloyd Jones, and that says at paragraph 65, 2243, despite the reference to a foreign sovereign coming into this country and the fact that the King of Hanover was directly impleaded, the decision is clearly of wider ambit and an important early authority demonstrating the existence of the principle of Act of State in English law. And for good measure, Lord Mance didn't regard Duke of Brunswick as a pure sovereign immunity case either. He simply said at 48, which is 2317, that it dates back to a time when the two strands of state immunity and foreign acts of state were not distinctly separated. And as to the case itself, Lord Sumption had quoted from Lord Cottenham his judgment begins at 3340. And just to set this up, this was a case of disputed appointment, as we say in our written case, where sovereign appointments had been made in respect of the property of the deposed Duke of Brunswick, whereby guardians were appointed. First the replacement Duke of Brunswick and then Duke of Cambridge, the Duke of Cambridge, and then later the King of Hanover. And a challenge was being made to the validity of those appointments. And the court here heard that that wasn't a challenge that could be entertained. And Lord Cottenham says at the bottom of 3340, the whole question seems to me to turn upon this. That is to say, for the purpose of the decision, it's not been otherwise contended at the bar, and if it had been, it's quite clear that the contention could not be maintained, that a foreign sovereign coming into this country cannot be made responsible for an act done in his sovereign character in his own country, whether it be an act right or wrong, whether according to the constitution of that country or not. The courts of this country cannot sit in judgment upon an act of a sovereign effected by virtue of his sovereign authority abroad, an act not done as a British subject, but supposed to be done in the exercise of his authority vested in him as a sovereign. So that's the general principle of a subject matter immunity, and it's clear from the subsequent paragraph that he's not deciding the question of state immunity. Therefore, I avoid the question of sovereign immunity as an individual. Therefore, I avoid the question, which doesn't necessarily arise, how far a foreign sovereign coming into this country is amenable at all. And then one sees at 3342.
I'm sorry, just before we leave 3341, is the passage further down the page of any relevance that, well as a question discussed about the constitution, whether the Constitution of Germany authorised the act?
Well, not directly. That was what's being discussed there is the steps taken to depose the Duke of Brunswick, whereas the focus for my purposes is on the subsequent appointment of the guardian over the property.
Yeah.
And then that's clear from 3341, where in the final paragraph he says, then comes the instrument under which the defendant or his predecessor, the Duke of Cambridge, acted. That's the instrument of appointment, and the validity of which was under challenge. And over the page at 3342, 4 lines down in the second paragraph, as such heads of sovereign states, and by virtue of the law and the constitution to which they refer, they're authorised to give direction for the appointment of a guardian, not as individuals, but as the heads of sovereign states. And then 2 paragraphs down, it's true, the bill states that the instrument was contrary to the laws of Hanover and Brunswick. But notwithstanding that it's so stated, still, if it's a sovereign act, then whether it's according to law or not according to law, we cannot inquire into it. And he goes on to say that the position would have been different if it had been a private transaction, and that's consistent with the submissions I was making yesterday about the great difference it would have made in this case if we were talking about private acts of board appointments.
Well, I'm just wondering, in the passage you've just taken us to, it says, if it is a sovereign act, is the passage in the first full paragraph on that page not dealing with the question whether it was indeed a sovereign act, and referring in that connection to the powers given to the head of state by virtue of the law and the constitution to which they referred?
Yes, but that's the basis upon which it's said that he was acting as a sovereign.
Yeah.
But then, critically, whether or not those powers were being lawfully exercised is not a question that the court will inquire into. And this one sees from the further paragraph, it's a matter, if it in the middle of the page, if it be a matter of sovereign authority, we cannot try the fact whether it be right or wrong. So that the prior paragraphs were just setting up the fact. We're not talking about private acts of guardianship, and this was being done in a sovereign capacity. And then it said there in the middle of the page, the allegation that it's contrary to the laws of Hanover, taken in conjunction with the allegation of the authority under which the defendant had acted, must be conceded to be an allegation, not that it was contrary to the existing laws as regulating the right of individuals, but that it was contrary to the laws and duties and rights and powers of a sovereign exercising sovereign authority. If that be so, it doesn't require another observation to show, because it has not been doubted, that no court in this country can entertain questions to bring sovereigns to account for their acts done in their sovereign capacities abroad. And then Lord Lyndhurst, I'm entirely of the same opinion. Lord Brougham over the page. I entirely agree with both my noble learned friends upon this subject. And then Lord Campbell's important because he says that the Duke of Cambridge, who was the original appointee as a guardian, couldn't have been sued either, which makes clear that it's not the outcome isn't dependent upon the sovereign status of the King of Hanover. It's based upon the subject matter, and one sees that about 10 lines down on 3343. The inclination of my opinion certainly is that the Duke of Cambridge couldn't have been sued in a court of equity in respect of what he had done under this instrument. And in those circumstances, what Lord Campbell later says in Wadsworth about sovereign immunity, that's a case relied upon by my learned friends, takes him nowhere. Duke of Brunswick, as a case, did indeed touch on the subject of sovereign immunity, but it's the act of state aspect which is identified by both Lord Wilberforce in Boots and relied upon by Lord Sumption in paragraph 230. And this is an appointment case. An early authority is to the court's refusal to entertain the challenge to the legality of a foreign sovereign appointment within his own territory. And there is no change to the underlying ownership of the property, but what's being done is to effect a change in control by appointing a guardian over the property which belonged to the deposed Duke. And the property falling within that guardianship was not only in Brunswick, where the appointment was made, but also in Hanover, England, France, and elsewhere. And one sees that from 3336. Sorry, I beg your pardon, 3335. Number paragraph 2, the appellant was the reigning Duke of Brunswick and was in his private capacity seized and possessed of real and personal estates of considerable value in Brunswick, England, Hanover, France, and elsewhere. And then the guardianship itself was legally situated in Brunswick. One sees that from the middle of 3336. By Article the 6th of the Instrument of Appointment, the guardianship was to be considered as legally established at Brunswick, where it was to have its locality. And so that local appointment took effect extraterritorially over all the properties, even though the act of appointment itself, as emphasised by Lord Cottenham, was being undertaken in the Duke of Brunswick's own country. And he specifically refers to acts done in his sovereign character in his own country. And that was agreed with by all the other law lords. And it was specifically alleged that such appointment was unlawful under the laws of Brunswick, Hanover, and England. And that's at 3342. And although I'm slightly reluctant to press the comparison too far, because it's a very early act of state authority, it's actually the closest to our facts of all of the cases, because it's a territorial sovereign appointment which has an extraterritorial impact because the property over which the appointment is effective is located in various other sovereign states, and the appointment is alleged to be unlawful, including under its own law, but because it's an act of sovereign authority, the court says it won't inquire into it. And that's true. It's true that there was no declaration in that case of unlawfulness by a Brunswick court, but we say it would have been irrelevant if there had been, because it would have been the same thing that the court was being asked to do here, which would have been to say to a foreign sovereign in respect of his sovereign acts, I'm terribly sorry, I'm not going to recognise them because I consider them to be unlawful. And so that's Duke of Brunswick. Princess Paley is another important decision. The Maduro board seek to downplay it by saying that the aspect of the reasoning upon which we rely was obiter. That wasn't the view of Lord Sumption, who cited Princess Paley at 230. He dealt with it as a case earlier in his judgment at 215, which is at 2380. And he explains that all three members of the court held that effect fell to be given to the decree, the Soviet decrees, as part of the Lex Citus, the property having been taken in Russia. But they also upheld a distinct argument that even if, as the plaintiff alleged, the decree did not justify the seizure, it was an act of state into the validity of which this court would not inquire. And so it's absolutely plain that Lord Sumption is analysing this as an alternative ratio of Princess Paley. Lord Nance specifically referred to paragraph 38 of his judgment to the third ground in Princess Paley, that's the alternative ratio, and he was prepared to assume, for the purposes of the argument in Belhage, that there was a second rule which applied at least in relation to property, although he felt it went no further. And that second rule would apply in relation to unlawful executive acts. And so he provides no support for the suggestion that this is obiter. Also, how it was treated in one of the academic authorities which the Maduro board themselves cite at paragraph 139 of their case. That's a 1982 article in the Virginia Journal of International Law, the author of which was Lord Lloyd Jones. And if I could show you Lordship's that at 5935.
You are aware that you're eating into Sir James's time.
Yes, I was planning to be finished in about 15 minutes.
Well, that will leave Sir James half the time he was supposed to have.
Yes, we haven't revised any of the timetable based on the time that was lost with the housekeeping yesterday morning.
No, that was designed to speed things up. Unfortunately, it didn't. We didn't get to the real point of the case until 5 to 4 yesterday afternoon. Well, I think myself that it's important to us to hear from the Secretary of State. I think you need to bring your submissions to a close quite soon.
Yes, more. Well, in which case, I won't take any time, with the greatest respect on Lord Lloyd Jones's article, other than to identify that he saw Princess Paley as relying upon the alternative ratio, or being important in relation to the alternative ratio. And the Privy Council didn't regard Princess Paley as relying upon or as being obiter either on this aspect. There's a case called Piramal Carmal, which perhaps unfortunately wasn't cited in Belhage, no doubt because of the limited nature of the argument there, which was about human rights issues, effectively. And it's at 553. 5355 is where the case starts. The facts here were that the government of Indore, which was a foreign sovereign state, was seeking financial redress against a corrupt court official, Shankar Rao, who had misappropriated state assets. And Shankar Rao owed money to Mr. Carmal, the respondent, on a trading account. And the government of Indore, through its chief of police, sought to recover the sum owed by Mr. Carmal to Mr. Shankar Rao. And then subsequently, the plaintiff, Mr. Piramal, then obtained a pre-judgment attachment from the Bombay court. And Mr. Piramal was saying that he got there first and has seized this property first. And the government of Indore was saying, well, no, we've got that property because Mr. Carmal had transferred it over to us. And there were two parts of the argument. There was a question of lex citus as to where the citus of the debt was, whether in Bombay or in Indore, and that's not relevant for present purposes, other than to illustrate the territorial scope point. But what was alleged was that there had been no proper basis identified by Mr. Carmal that the seizure by the Indore government was a valid seizure of property. And that was an argument being advanced by a not exactly underpowered council team of Wilford Green and Tom Denning. And they were saying that this hadn't been shown to be a valid act of state. And there seemed to be considerable force in that submission, given that no one had identified any valid lawful indoor law basis on which here the chief of police could sit down this man in a interview room and say transfer their assets to the government. And indeed, the only evidence, so-called, that was relied upon was the statement by the Prime Minister that everything that had been done was entirely in accordance with indoor law. And so it wasn't even like Princess Paley, where there were, on the face of it, decrees relied upon which appeared to provide a lawful basis. There seemed to be real force in the point that the indoor government didn't have a proper basis to have expropriated this money without any judicial process, and just having been done by the Chief of Police. And that seemed also to be supported by the fact that after it had happened, the government had taken steps to regularise the position and to confirm the validity of what had been done. And Lord Atkin at 5358 he starts his judgment and explains at 5359 about Shankarao being a court official.
I wonder if we can cut to the chase. Are you taking us to the dictum of Lord Atkin on page 5367?
Yes, my Lord, I'm terribly sorry, yes.
Yeah.
He says there that this seems to ignore the evidence of the Prime Minister of the State. I've referred to that. He refers to Luther and Sager and Princess Paley. This court will not inquire into the legality of acts done by a foreign government against its own subject in respect of property situated. The proposition is well established as a rule governing the decisions of a domestic court in relation to the acts of a foreign government, and the departure from it is calculated to cause confusion. In fact, the final sentence, although in the quotation mark isn't a quote from Princess Paley, it's actually Lord Atkin's own words. And the reason this is an important case, and the contrast with Princess Paley is important, because it is only really on the basis of the Executive Act. It's not done by way of an alternative ratio saying, yes, there's a lawful basis, but it doesn't matter. I can reach the same result by an Act of State. It is the Act of State which is relied upon. And Princess Paley, in other words, I can take quickly. We say it's not Obiter. Lord Justice Scrutton is clear in dealing with the US authorities and explaining how that's a proposition of English law. And we don't understand Princess Paley, well, we don't understand the point made by the Maduro board saying that Miss Princess Paley is better read as a ruling on retrospective effective recognition, because that was decided by Luther and Sager as the retrospective effective recognition. And Princess Paley went further in relation to the fact that the executive acts of seizure were to be treated as valid, irrespective of the position under the Russian municipal law. And Re-Amand is another case which we say is important. That's at 4505. This again wasn't cited in Belhaj. It's a military conscription case. And identifying the scope of the Act of Doctrine in relation to persons. And on the unusual facts, the doctrine wasn't applied. It was held by the three-man divisional court that they could and should investigate the legality under Dutch law of the decree of conscription which had been issued by the government in exile of the Netherlands, which was in exile in London during Nazi occupation during the Second World War. And Mr. Amand had been purported to be conscripted and was objecting, saying that what's been done isn't valid as a matter of Dutch law. And the courts upheld the general principle by reference to Underhill and Princess Paley and Luther and Sager and the Act of State doctrine, that there was this, the general position was that shouldn't be investigated because that was an act of sovereignty by the Netherlands government and her queen. But on the unusual territorial aspect of that, because the Netherlands government was in exile, because Mr. Amand was lawfully in England, subject to the protection of English law, then the courts were prepared to investigate the validity of the Dutch decree and indeed upheld it. But the key reason why we rely upon that is that's an illustration of the application of the doctrine to acts which extend some way beyond just executive seizures of property. Just very briefly on Belhaj.
I think what we should do is allow you to complete your submissions, but it will have to come out of the reply time, which you would otherwise have had, so that Sir James has the proper amount of time to address us on behalf of the Foreign Secretary.
Yes, Lord. My Lord Belhage, I focus on Lord Sumption's treatment of the question of lawfulness, and we say that Duke of Brunswick and Princess Paley amply support his conclusions, and so did Piramal, which wasn't cited, and then Amand also supports the breadth of his conception of the scope of the doctrine as applying to executive acts generally. But on the whole Act of State question, my Lords, we gratefully adopt as an extensive tour of the jurisprudence and an identification of the relevant principles, everything that he says from 198 onwards. And where there are some slight differences of emphasis between his analysis and that of Lord Mance, we say it's Lord Sumption's analysis to be preferred. For instance, on the immunity points, Lord Mance suggests that some of the US cases can be explained by reference to state immunity, whereas it's observed by Lord Sumption at paragraph 211 that in Underhill and Hernandez and Hatcham Bayers, the defendants had submitted to jurisdiction, so there wasn't an immunity point in play there. Lord Newburger, on this key issue of legality, left the point entirely open. He saw the arguments both ways, but said that there hadn't been full argument, and so it was appropriate to leave it open. And then the Court of Appeal at 144 of their judgment had cited Lord Mance at 65 for what they regarded as an important insight into this area. And if I could just show you, Lordships, that passage. This begins at 2325, paragraph 65. And he's dealing with the rule in Dicey Rule 3 in relation to acts of state. And then at 2325 at G, he says, but a potential problem about such a reading is that it equates sovereignty with executive activity. In states subject to the rule of law, a state's sovereignty may be manifest through its legislative, executive, or judicial branches acting within their respective spheres. A rule of recognition which treats any executive act by the government of the foreign state as valid, irrespective of its legality under the law of the foreign state, and logically it would seem irrespective of whether the seizure was being challenged before the domestic courts of the state in question, could mean ignoring rather than giving effect to the way in which a state's sovereignty is expressed. And that was cited by this Court of Appeal. It's been seized upon by the other side. But what Lord Mance describes as a problem merely reflects the potential which is inherent in the very concept of Foreign Sovereign Act, that its status internally within the domestic legal system of the foreign state may diverge from how the act falls to be treated externally in the domestic courts of other foreign sovereign states. And the consequence of that divergence can only be worked out domestically. The fundamental principle is that a foreign sovereign act, in contrast to a private law act, doesn't depend for its status upon its validity under its own law. I've made those submissions already this morning. And a sovereign act falls to be analysed under a different framework. And two related points. HMG has here formally recognised Mr. Guaidó as president, just as in Libya it recognised a government. And by definition, that's a recognition of sovereignty, which binds the court. And we submit that it's fundamentally incompatible with the recognition of sovereign status of the president or government, as the case may be, to then subject their acts to the same scrutiny before a domestic court as would apply to a private citizen. And relatedly, HMG chose to recognise President Guaidó despite the STJ, the Venezuelan Supreme Court, affirming Mr. Maduro's status as president after the disputed elections. And HMG has maintained its recognition despite the fact that the Venezuelan Supreme Court has expressed the views which are quoted by Mr. Justice Tier at paragraph 53, page 32. And Mr. Vinyl says it's uncomfortable for the courts to have to ignore what the STJ said. And Lord Leggett clearly has concerns about the extent to which an English court can properly put to one side these decisions. But HMG has already chosen to ignore what the STJ has to say about the status of the Venezuelan presidency. And so it's a short step from that position to then recognise that the court is also not required to have any regard to what is said about the legality of the status. That's not because it treats the court as corrupt or wrong, but simply because it's irrelevant, because one's engaged in a different inquiry as to the status of sovereign acts. And there's no reason to suppose that such potential for divergence causes any real practical problems. The present type of dispute over the status of sovereign acts arises only infrequently, and only then in situations of war, revolution, or in this case, a constitutional crisis. The practical difficulties would be far greater trying to apply a version of the doctrine which distinguished between whether or not a state was subject to the rule of law, and a version of the doctrine which no longer treated all states as equal could no longer then be said to have its rationale in the sovereign equality of states. So we say that what Lord Mance said at paragraph 65 is interesting, but it cannot possibly be used to unravel the doctrine altogether, because to give primacy to the Judicial Act would not only turn UKOS on its head, but also completely subvert the wider Act of State doctrine, because it would then identify legality under the foreign domestic law as being the defining criterion for the recognition of its legal effect. And as I've submitted, that's true for private law acts, but it doesn't apply in relation to sovereign acts. So those are my submissions on our issue 3 appeal.
Thank you very much, Mr. Fulton.
I'm going to address you, if I may, on the basic and principled approach to recognition first, and briefly. Then I'm going to make some submissions on interpretation, and particularly the approach that the Court of Appeal took to interpretation. And then, particularly given the debate that has occurred in this court since yesterday morning and after 4 o'clock, nearly at 4 o'clock yesterday, I might not be able to resist something on foreign acts of state, but it will be very brief. So far as the basic and principled approach to recognition is concerned, the propositions that I'm about to submit are good, apply in circumstances in which Her Majesty's government decides, in response to a request from a court for a recognition answer, to provide such an answer. Of course, that can be in response to a request from a court, or it can be otherwise. A certificate can be issued of the Secretary of State's own motion, and there is sometimes a statutory process for issuing such a certificate, as you know, for example, under Section 21 of the State Immunity Act. The propositions are common to that situation, whether it involves recognition or non-recognition of a state or of a government, by way of exception to the 1980 policy, or of a head of state or head of government. Different issues and a different approach applies in circumstances in which there is no such request, or in which Her Majesty's government declines to provide a recognition answer in the application, say, of the 1980 policy. Then you're thrown into Mr. Justice Hobhouse, as he then was, his analysis in Somalia and Woodhouse-Drake, although a little care with that authority is needed because it appears that Mr. Justice Hobhouse assumed that following the change in policy in 1980, Her Majesty's government would never provide a recognition answer, which misconception was corrected, amongst others, by Mr. Justice Mance, as he then was, in the Kuwait Airways litigation. So 3 initial but key points on the principled approach. Firstly, unless the government has already provided a certificate, pursuant, for example, to a request from the parties, the practice of the courts has always been to ask what the position of the government is on recognition. You get that as the practice first acknowledged and established in Kelantan at paragraphs or at pages in the electronic bundle. I'm going to give you all the page references in the electronic bundle, 2546 to 7 in the speech of Viscount Cave. And as it was put in the Mendy case, this time 2955 to 6, as the court put it there, the correct course or the correct procedure is to ask, and indeed as they there described it, it is the only procedure by which the court can inform itself whether the relevant party is recognised by Her Majesty's government. That's the first proposition. It's about practice of the courts. The second proposition is in 2 parts. When a recognition answer is given, A, it is for the court to consider its meaning by examining what is said and not by conducting an examination of extraneous factors or documents outside what is said in the certificate, Mr. Otte described as the four corners principle, and B, if what is said is clear, the answer is conclusive. And I can just take the authorities, if I may, relatively swiftly. I think you referred to almost all of them yesterday, but if you are able to jump relatively quickly onto the electronic screen, 2546 in Kelantan, to take that one first. Viscount Cave at 2546-7. The reference I gave you earlier on. It has for some time been the practice of our courts, as you see about 6 lines up from the bottom of page 2546. Running over the page, in particular the first sentence on page 2547, information of this character was obtained from the Secretary of State, from a Secretary of State, and accepted without question in Taylor and Berkeley. Citing a series of cases, Taylor and Berkeley and Miguel. The relevant passage from Taylor and Berkeley, if you jump forward to page 2567 in the speech of Lord Sumner, you will see the relevant citation from Taylor and Berkeley about a third of the way down page 2567. You see a reference in italics to Thompson and Berkeley. That's a citation of the case. It's in fact Taylor and Berkeley. There is another Thompson and Berkeley, but it's not this one, as one sees from the reference to 2 Sim 213221, which is into Taylor and Berkeley. The courts of the king should act in unison with the government of the king. This seems to be rather a maxim of policy than a rule of law. And then Miguel and Sultan, is the I think the Lord Isha passage. So those are the citations. And then at 2549, still in the speech of Viscount Cave, picking it up 4 lines from the bottom of 2549, if after this definitive statement, can you read from there to the end of the paragraph? Duty of the court to accept it as conclusive. Viscount Findlay at 2555. And as you see from about halfway down that page, he positively declines to enter into the inquiry on the basis that he has no power to do so. We're asked to say that it's for the court and for this House in its judicial capacity to decide whether these restrictions were such that the Sultan had ceased to be sovereign. We have no power to enter into such an inquiry, the reply of the Colonial Office to Master Jeff and so on, states that Kelantan is an independent state and the Sultan is the sovereign ruler. And then over the page on 2556, the final sentence, halfway down the page of the longest paragraph on there, the answer of the king through the appropriate department settles the matter, whether it depends on fact or law. Then Lord Sumner at 2564-5. The last line on 2564, the status of foreign communities and the identity of the high personages are matters of which the courts of this country take judicial notice. And then the key passage, perhaps, is from there down to the end of that long paragraph on page 2565. I'm not going to go through it because parts of that, at least, or parts of what feature later, are called into question by Lord Atkins in Mendy. But history may have been relatively unkind to Lord Sumner, because although it's right that he identifies the rationale for the principle and anchors it in best evidence, what in truth he is saying, as you see from that long paragraph on page 2565, is that although that might be the rationale, it's treated as being conclusive. put the second notional hole punch into page 2565. Accordingly, where such a statement is forthcoming, no other evidence is admissible or needed. And then see from there to the end of the paragraph. So that's Lord Sumner. Lord Carson, to the same effect, 2571.
I mean, perhaps what's particularly helpful is perhaps the first full sentence on page 2565, that instead of requiring proof, they act, that is the courts, act on their own knowledge, or if necessary, obtain the requisite information for themselves, which is what they do by applying to the Secretary of State.
Yeah, exactly. Lord Carson, if I may briefly, 2571, to the same effect. And you'll remember, I was right, I think, in remembering that the citation from Lord Esher had echoed with Viscount Cave. You see that 2571 about a third of the way up from the bottom. I agree with your lordships that the courts of this country are bound to take judicial notice, that's a phrase that keeps being repeated, of the status of any other country in accordance with the information afforded to them. And then Lord Esher is cited from Miguel. There's a rather broader passage from Lord Esher which is quite interesting, so you might care to notionally note at least next door to Lord Esher, see for that purpose 4052, which takes you directly to the slightly longer passage from Lord Esher. And then you have the chaos and confusion comment that my learned friend Mr. Ottey drew attention to at the bottom of 2571. It might be thought that Kelantan, at least, is an interesting example of the approach, the correct approach to be followed, because the argument there was that although the Secretary of State had said on the face of the certificate that Kelantan was an independent state and its sultan a sovereign ruler, that needed to be qualified, so it was said, by the documents which the Secretary of State had attached to the certificate, to reach the conclusion, in effect, that if you looked at those documents, it wasn't an independent state. But see, for that purpose and for the nature of that argument, 2548, again by the notional second hole punch, upon these documents, it was argued on behalf of the appellants. You see that about 7 lines up from that paragraph, the end of that paragraph, it was argued and so on. So you see the nature of the argument. That was the argument, and they had no truck with it. More accurately, they had no truck even with that in circumstances in which the documents that the Secretary of State enclosed with the certificate might well not have borne out that conclusion. Go back to 2571 in judgment or the speech of Lord Carson. Where he starts his speech, I must confess that it was open to me to disregard the statements contained in the letter of the Secretary of State that Kelantan is an independent state, present Sultan is the present sovereign ruler thereof. I would find great difficulty in coming to that conclusion of fact, having regard to the terms of the documents enclosed by the Secretary of State. So that was the conclusion, despite that initial judicial reaction to the documents that the Secretary of State had concluded. One needs to be a little careful, therefore, with the point that my Lord Hamden put to my learned friend, which is that, which I think he accepted as accurate, which is, might it be permissible to look at documents that are actually referred to in the certificate itself? I think my learned friend said yes. I'm afraid I would answer no to that question, because these documents that Lord Carson expressed doubt about were in fact referred to on the face of the certification, as one sees from earlier in the judgment. So the conclusiveness of the principle operates, as its name suggests, to preclude examining the correctness or the foundation for the certificate by reference to any extraneous matters.
In that case, and perhaps one might say in this case, what the certificate says is clear and unambiguous, and you can't introduce documents to contradict it. We don't need to decide, but do you go so far as to say that in another case where it's argued that although this certificate looks clear enough, there is some ambiguity in it, you can never look at anything else that might resolve that ambiguity and show that it is actually clear if you understand it in it by reference to some documents outside it.
My Lord, I do go that far, and I go that far on the basis of these authorities, and I also go that far for the separate and principled reason, which is that it is always open to a court, and this is the correct procedure, to go back to the Secretary of State to resolve the ambiguity, rather than seeking to resolve it for itself. And one thinks, for example, before one gets to that as the alternative process, but one thinks, for example, of the fact which was asserted to be self-evident in Carl Zeiss, which was that the USSR had recognised the GDR as an independent sovereign state. And so they were setting their face against looking even at those extraneous matters. Now, it's possible, I suppose, in principle, to say that Carl Zeiss also was a case in which the Secretary of State has expressed clearly the view. So it doesn't exactly determine it, but my submission is that at least it's much more consistent with all of these repeated assertions as to how you go about doing it, to stick with the four corners rule, and if genuinely you are then left in a state of uncertainty or ambiguity, then you go back to the Secretary of State.
Is there any case in which the court's ever gone back to the Secretary of State? And I'll ask for a clarification.
Well, this one.
That depends.
Apart from this one, I can't think of one. I'll think and see if I can,
Yeah.
if there is one in which they've gone back.
My recollection was that there was something to that effect said by Lord Reed in Carl Zeiss.
Might be.
Let's see.
2462 I've got in my...
Oh, yes, what I had in mind was 2463.
2463.
After referring to Lord Justice Diplock's dictum,
Yes.
he says at E, at a late stage in the argument, counsel made an application that further questions should be addressed to Her Majesty's government.
Yes.
That would be a perfectly proper thing to do if your lordship was of the opinion that the existing certificate is ambiguous.
Or insufficient, yeah.
Yeah.
Yeah, and that's a useful and helpful passage. That's a useful passage for that, but and also I submit for what precedes it, effectively that from page 2462, first full paragraph, right over to the end that my Lord has just been reading from is useful there, not least because of the disagreement with the approach of the Court of Appeal. Just to complete the references, so far as the Mendy case is concerned, the matter was dealt with there. At page 2959, if you would just briefly get that up, in the short speech of Lord Wright. As he put it, as you see there, the court is bound without any qualification by the statement, ... the contents of which are not open to be discussed by the court on grounds of law. And then we've looked at the judgment of Lord Reed in Carl Zeiss, with whom the other members of the court agreed. Key passages we respectfully submit, rejecting the approach of looking at extraneous facts. 2462 at G to 2463, pretty much to the bottom of the page. And Lord Reed adopted precisely the same reasoning and the same approach in his judgment in the Privy Council. I don't invite you to turn it up, but the judgment in the Privy Council in Madzimbamutu, which is at page 2785 by the letter F.
Yeah, you might say that in the Mendy case, Lord Atkin's approach at 2956 implicitly supports what Lord Reed was saying, He says that our state cannot speak with two voices.
Yes.
The judiciary say on such a matter, the judiciary saying one thing, the executive another. Our sovereign has to decide. So you might say, well, the implication of that is that if the judiciary aren't clear, they need to go back to the executive.
Yes. Oh, quite so. And you also get from that same page, if you're there, 2956 at the very top, second line down for the next 3 or 4 lines, where he says, I pause there to say that not only is this the correct procedure, but it's the only procedure by which the court can inform itself of the material fact whether the parties ought to be impleaded as the foreign sovereign state. But again, it's all consistent. It's a consistent repetition of the same basic ideas. This is a matter for the government. This is the only appropriate and correct procedure for doing so. Resist all temptations to look outside the 4 corners and try and determine it for yourselves by reference to whatever material there might be. One can analyse it on the basis that, therefore, the only relevant fact is whether or not Her Majesty's government has recognised and is prepared to recognise the person in question. And one gets that idea from, I don't invite you to turn it up now, but you get that from the House of Lords in Engelke and Mussmann, which is in the supplementary bundle at page 283, where the court said this: when a question arises in the law courts as to whether a ruler is a sovereign and a proper Secretary of State is consulted, the right answer is not, quote, AB is a sovereign, quote, close quotes, but, open quotes, AB is recognised by His Majesty as a sovereign. And the consequence, as Dr. Mann has put it, is that the Foreign Office, if they are the relevant department, speaks of what it recognises rather than of what exists. That's the principle, supplementary bundle 1278. And as he goes on, the reality may be entirely different from the fiction which recognition or non-recognition by a British government may create. So that's the second 2 lots of propositions with all of those references. Thirdly, the reason or the rationale for this practice and these principles is centrally based, we submit, in the separation of powers and recognising, in effect, the exclusive function of Her Majesty's government in this sphere, exclusive in the sense that what they say is conclusive and thus exclusive of the court's jurisdiction. So it's separation of powers at key, but these decisions, as you know, concern foreign policy. Specifically, they concern those with whom the government is prepared to have international relations, one sovereign recognising another, and comity. And those are judgments peculiarly for the government under the separation of powers. See, in particular, to go back to 2554, Viscount Findlay referring to the practice and the conclusive effect of it. Such information is not in the nature of evidence, he says. It's a statement by the sovereign upon a matter which is peculiarly within his cognizance. That's a passage to which my Lord Lloyd Jones drew attention yesterday, and we respectfully submitted his key as the basis. You get the same idea in the speech of Lord Dunedin at 2561, where he ties the basic idea to comity. You see the passage 2561, third line into his speech. It seems to me that once you trace the doctrine for the freedom of a foreign sovereign from interference by the courts of other nations to comity, you necessarily concede that our own sovereign has in him the only power and right of recognition if our sovereign recognises and expresses, and so on. And the same idea also from the Mendy case, 2956, our sovereign, says the court, has to decide whom she will recognise as a fellow sovereign in the family of states, and the relations of the foreign state with ours must flow from that decision alone. Moreover, the judgments engaged in a recognition decision involve a range of what are plainly high policy choices for the government. That isn't an exercise that can be tested against objective or empirical standards. It's not, specifically and advisedly not, an exercise simply of assessing the facts on the ground, still less assessing simply the degree of authority actually wielded. And one voice is an expression or a consequence of these base justifications. My Lord will read your attention to it already. The key passage is in Mendy 2956. Our state cannot speak with two voices on such a matter, the judiciary saying one thing, the executive another. And that no doubt explains why in the later cases, the more modern cases, separation of powers has sometimes been expressed, and the conclusiveness principle and the one voice principle to which they lead has sometimes been expressed as a public policy constraint against acting inconsistently with what the government has said by way of recognition. That was the way it was approached by Lord Donaldson in Gur and by Kuwait, the Court of Appeal in Kuwait, citing Lord Donaldson. See, for that purpose, paragraphs 343 at 3779 and 349 at page 3780. And note finally, and consistently with all of that authority, Lord Sumption in Belhage and Straw at paragraph 225, identifying the underpinning rationale 2386. It might be thought that the position was very neatly expressed in a slightly different context by my Lord Jones in the CC case, if you recall that one about Somaliland, where my Lord said at paragraph 130, page 4653, it is for the executive to decide on the entities with which it will have dealings in the conduct of international relations. That was a statement made in relation to our dealings with a non-recognised state, but the same thinking, we respectfully submit, applies to recognition too. So the result, which is inherent in the consistent principle that the certificates are conclusive, is that judgments on which a recognition answer might be based are not reviewable. They fall within the paradigmatic category of non-reviewable decisions and have been recognised to do so. Their nature and subject matter, to take those concepts from Lord Roskill in GCHQ, their nature and subject matter are such as not to be amenable to judicial review. They are, to take the phrase from Lord Phillips and Abbasi, part of the forbidden area, 106.3 of Abbasi, the famous statement, supplemental bundle 737. Or they are, if you want to take the concept from Lord Carnwath in Youssef, at 25 to 26, supplemental bundle 1196 to 7, they are matters of high policy. And we've set out the authorities that specifically recognise that recognition decisions are, as a category of decisions, non-justiciable. Supplementary case paragraph 15, the key authorities at a level below this court, but the key authorities are Trornick, supplemental bundle 643, and Pahang. See in particular in Pahang, it was a Court of Appeal authority, Lord Justice Morris Kerr, paragraph 16, page 4245, and Morbick at 32 at 4249. And there is no basis in later authority to overturn that approach. Indeed, in Pahang, as you will see when you go there, if you go there, paragraphs 14 and following, a specific invitation was made to the Court of Appeal to overturn those House of Lords authorities on the basis, as I think Mr. Singh put it in argument in one of these cases, one by one the bastions have fallen. But not having it. The Court of Appeal said, well, they may have done, but this one isn't. So a specific rejection of the idea that this was out of kilter with the modern approach. And we do respectfully submit that any suggestion that prerogative powers in the sphere of foreign policy exist in a spectrum would not help the other side in relation to this argument, because on any view, if the spectrum is intended to refer to Lord Carnwath's analysis and Youssef, we are right at the top end of it. We are in high policy. But there is likewise no force in the point or the attempt to rely on Miller too, and that is for the simple and short reason that there was, entirely understandably, specific recognition by the Supreme Court in that case that there are some exercises of prerogative power that would be non-justiciable. Miller 2, whatever else it may stand for, does not stand for the proposition that all exercises of prerogative power are justiciable, expressly to the contrary. And we respectfully submit that on clear and consistent authority, this is one of them. So that's the position in relation to authority. There's equally no principal basis on which to overturn that consistent line of House of Lords and lower authority. And that is because they are essentially based, as we've seen, on the fundamental underpinnings of comity and the separation of powers. And there has been no change there. On the contrary, as one sees from the raft of recent Supreme Court cases analysing these issues of separation of powers and what they mean. Don't need me to remind you again in this case about institutional competence and democratic accountability, but both are engaged, both are constant themes. See Begum in the Supreme Court Supplemental Bundle 893, based on Raymond and Lord Hoffman, which itself is in the Supplemental Bundle at 1209, and C for the recent reiteration of the importance of respecting the separation of powers, SC in the Supreme Court and AB in the Supreme Court. Those were, of course, principles of, or separation of powers bearing on the principle of respect for government decision-making and margin, but they also explain why sometimes at the top end of that there is forbidden territory. And this is a particular and a particularly important part of the allocation of constitutional responsibility we submit. Recognition is allocated to Her Majesty's government, and the one voice principle is integral to it. Two further authorities simply to note without turning them up on this set of principles. First of all, Mr. Justice Mance in Kuwait, I've referred to it already. It is, we respectfully submit, a helpful and short analysis, correctly identifying all of the relevant principles and indeed the slight question mark over Mr. Justice Hobhouse in Woodhouse. That's at 2656 and following. I won't go through it now, but there's a short 2 or 3 page section which is of real use. And secondly, if I may respectfully say so, bringing it bang up to date, the Court of Appeal in Bryche, Lord Justice Popperwell giving the leading judgment, we respectfully submit in relation to that there is good, useful and accurate, if I may respectfully say so, analysis of all of these principles, paragraph 1 in particular, but see also for the treatment of the one voice principle and how it should operate, paragraphs 41 to 43, 56 to 58, and 62 to 63. The case itself starts at electronic 2831. So we respectfully submit that we have a long established for coming up to 200 years, because I think the Taylor case that was referred to by Viscount Cade started in, was handed down in 1828. So we have a consistent 200-year-old set of principles, repeated House of Lords authorities, all of which are absolutely on the same points. And the key and fundamental point is that certificates of this kind are A, to be sought, and B, are conclusive. Can I turn to interpretation, if I may? Interpretation of the certificate. And I start with the approach to interpretation. Generally, you won't be surprised to hear me say, the aim of the courts is faithfully to seek to ascertain the intention of the government. This is not, if I can put it facetiously in this way, an ouster clause. The court should not be astute to find ambiguity or alternative possibilities based on the imaginings of those in whose interests ambiguity might lie. The true approach, again from Dr. F.A. Mann, that we've set out in the case at footnote 14 on page 2138. It's the second quote from 57 of Dr. Mann's article, Foreign Affairs in the English Courts. The practice of obtaining the executive certificate and the rationale supporting it cannot be justified unless the courts take every possible step to ensure that their interpretation of the certificate accords with the executive's intentions. And if you want that statement in the raw or surrounded by the earlier bits of it, see page 6048. Which will take you to the Mann article. So the starting point here is that the court has asked, and the Foreign Secretary has decided to answer. This is evidently not what is sometimes given by way of a certificate, which has been called in euphemistic terms a temporising certificate. This is not deliberately vague for the purpose of trying to ensure that particular foreign policy interests are protected. So the Foreign Secretary has been content to communicate the person that the government has decided to recognise as the head of state. That's the spirit of the question and the spirit of the answer. Her Majesty's government wishes to say to the courts who it is that has been recognised. And that takes one to the short points on interpretation. The first of them is that the questions are relevant to the answer. The simple question was asked, who does Her Majesty's government recognise as head of state or head of government? That's at page 904 in the electronic, if you want the letter asking the question from Mr. Justice Robert Knowles. In context, that question was designed essentially, and understandably given the nature of the litigation, to pose a binary choice. Is it Mr. Guaidó or is it Mr. Maduro? At the very least, a binary choice in answer to that question between one and the other was a possible answer. And that takes me to the second point on interpretation, which is very short indeed, which is that the answer is clear. The UK now recognises Mr. Guaidó as President of Venezuela until credible elections can be held. Of the choices open, the Foreign Secretary has given, on behalf of the government, a single and unqualified answer. He recognises Mr. Guaidó. One president and one president only is recognised, and it's president that is the key, covering both of the questions that were asked, which split it out between head of state and head of government. The answer was given by reference to the presidency, point I'll come back to, but one president and one president only is recognised out of a field of two. By contrast, and the flip side is just as important as the positive, there is no recognition of Mr. Maduro at all. And
the word "the" might be thought to exclude the possibility of there being more than one.
My lord, yes.
Look, I think if I may, it is very important to think, given that at first instance, the decision was recognition. President or head of state, but not head of government. Whether Madonna's friend is saying that this answer in fact conveyed that absolutely critical point. I'm sorry to interrupt. I understood it doesn't have to say that that was it.
Well, I'm coming to that directly, so my learned friend needn't hold his breath for very long. The point that I was on is that it would be bizarre, as a faithful exercise of ascertaining who the government chose to recognise, to take the references to oppression, illegitimacy and the kleptocratic nature of the Maduro regime as support for a case that in some way, shape or form the government intended to recognise Mr. Maduro as the de facto head of state. As a matter of interpretation, all that is doing is explaining part of the reason for recognising Mr. Guaidó. And so it works against the attempt to suggest that Mr. Maduro is recognised in any capacity whatever. And there are echoes, if I may respectfully say so, of the reasoning of Mr. Justice Mance in Kuwait, where he took as quite an important consideration in terms of interpreting the certificate that there were serious international legal issues with the idea that the invading state could be recognised by the government. In any event, we respectfully submit, the plain meaning is that Mr. Guaidó is recognised for all purposes as head of state, and Mr. Maduro is not. There is no ambiguity created in this certificate. Thirdly, and in any event, to the extent that there was any ambiguity, it has been resolved. And lest there be any doubt about the ability of the government to clarify, if appropriate, through submission and or other statements rather than some formality, see for that purpose the Gagara case 2969, where the statements were relied upon as given in the litigation by the Attorney General and Counsel for the Treasury, and again in the Amand case 4512, receiving a statement from the attorney on recognition also. See generally on that point our case at paragraph 41. I pause there to consider the nature of the recognition actually given. The recognition indicates that the person or government concerned is entitled to represent the state, and that Her Majesty's government is prepared to treat or recognise them or it as such. It is a recognition of competence to represent the state concerned. That's the nature of it. See in particular in relation to governments the Lord Privy Seal, quoted in our case at paragraph 5. And that will be so, we submit, whether the person who is recognised acts domestically, and those acts become relevant abroad, as in this case, or whether the person acts on behalf of the state in their international relations, in other words, on the international plane. Where a person acts in their capacity as head of state or head of government, the government of the United Kingdom will recognise those acts as an exercise of authority by that person. What recognition and a recognition answer is doing is to tell the courts that the government is prepared to have a position on recognition and recognises or does not recognise someone in the capacity identified. So here, as we put it in our case at paragraph 35, Mr. Guaidó is recognised for all purposes for which the head of state can act as president. To the extent that he exercises that authority, the government will recognise that as an exercise of authority in that capacity. Mr. Maduro, by contrast, is not recognised for any purpose. We do not recognise him on any basis, if relevant, neither de jure nor de facto, whether in respect of his acts in Venezuela, as relevant in this jurisdiction or otherwise, or in respect of his acts on the international plane. Mr. Vinal may not have been wise in opening or in his intervention just now to take comfort, or the comfort that he appears to take, from the purported difference between a head of state and a head of government in this context. The answer that was given by the Secretary of State was given to the dual question, which you will have seen from 905, and was given by reference to who was recognised as the President. of Venezuela. If you just go to the Court of Appeals judgment at 112, and it's not for me to make points about how this was put below, but it appears, and I think relatively clearly appears, from paragraph 112 in the Court of Appeals judgment, page 65 in the electronic, unless you have it separately, that everyone has been proceeding through this litigation on the basis that the key question has throughout been whether or not Mr. Guaidó was recognised as the head of state, it being irrelevant for the purpose of these proceedings, as it's put there, whether the government had also recognised Mr. Guaidó as head of government. And the reason for that was explained by Mr. Justice Tier at first instance. I don't want to take up much time on it, but can I refer you to paragraphs 34 to 36 in Mr. Justice Tier's judgment below, page 109 in the electronic, where he said, as is common ground between the parties, the President, as head of the National Executive, directs the action of the government. The reason Councillor for the Guaidó Board concentrated on the President of Venezuela was not only the language used by Her Majesty's government, but also the appointments which are challenged in the BOE and DB actions by the Maduro board, or appointments made by Mr. Guaidó as President of Venezuela. So the Foreign Secretary, when preparing his case, had no understanding, including when he produced paragraph 41 of the case that you've seen that's been referred to, that there was any material distinction and focused on head of state rather than head of government for that reason. Nothing more can be read into to that than it being subject to the context of the litigation just described. So we respectfully submit that it matters not whether it's head of state or head of government. The recognition that was given was to the presidency question, which it might be thought from those descriptions of the courts below as to the nature of the issues, was the relevant question in any event. Fourthly, therefore, we submit in relation to the interpretation that de facto and de jure should not be treated as hidden possibilities creating ambiguity. I recognise you as president. Well, on what basis do you recognise? You don't say de facto, you don't say de jure. We respectfully submit that's the wrong approach. Those concepts were not in fact used as the first point under that. The recognition as head of state was a recognition without any de facto or de jure or other qualification from the field of two. And the reason, it might be thought, why those terms were not used was pretty graphically illustrated by my Lord Legate's intervention as to the drifting meaning of those concepts as a matter of international law and how they were to be taken and the various different potential meanings that could be ascribed to them. But they were not in fact used. I suppose in theory, even though they'd fallen out of practice, one could have split things out in that way and said we recognise Mr. Guaidó as de jure, Mr. Maduro as de facto, or something along those lines. But those terms would then have had to have been explained. In what sense are you using de jure? In what sense are you using de facto? And the fact is that the Foreign Secretary has deliberately chosen not to do so, at least as it were, until provoked beyond endurance, which led to the case at paragraph 41. But they have, as my learned friend Mr. Otti pointed out, as terms, fallen out of practice. We've given you in our case at paragraph 16 and footnote 16 the various references in relation to that. And that is significant because it means that it would be very odd, we submit, for the courts to take an unqualified statement where there is any question of a tussle for local authority and control as ambiguous, because it does not take on the various different conceptions that may be implicit within the concept of de jure and de facto, and then explain them. It's always open to the government not to respond if an unqualified recognition answer is not something it wishes to give. But in any event, as we point out, the working assumption is full recognition. for all of the reasons we set out in our case, including by reference to Professor Talman's statement quoted in paragraph 28 of that case. And that leads, we respectfully submit, to three key problems in the analysis of the Court of Appeal on this set of issues. First of all, the assumption is that key to understanding the intention of the Foreign Secretary was the choice between de jure and de facto. But that is a false dichotomy, we respectfully submit. The certificate tells the court who the Foreign Secretary recognises and is prepared to recognise as head of state. It's not simply a factual statement about who is running the country on the ground in fact. It's an expression by Her Majesty's government that it recognises a person as having the authority or competence to act. And that distinction is key and runs through all of the thinking in the House of Lords and other cases. You could recognise someone in that capacity even if they had no current ability in their own country to exercise any authority and control. So that's the first problem, it's a false dichotomy. The second problem is it's using the outmoded concepts I've identified, and the practice is not to use them. So to use those to drive the analysis of intention is to use a false basis for that purpose. Not merely a false dichotomy in principle as the final point under this first submission, not merely a false dichotomy in principle, but it ignores the fact that the Foreign Secretary has evidently deliberately chosen not to use those concepts to qualify or split recognition. That's the first problem, therefore. The second problem, and the next assumption by the Court of Appeal, appears to be that the Foreign Secretary could not have intended to recognise Mr. Guaidó in the full sense, if I can use that, because Mr. Maduro was in fact exercising control over some or all of the aspects of government on the ground in Venezuela. And the first problem with that is that it starts outside the four corners of the certificate and then uses the court's analysis of the factual position on the ground, whether by way of assumption or evidential finding, compare Carl Zeiss taking notice in the Court of Appeal of the fact that the USSR recognised the GDR. It steps outside the four corners and then uses that analysis of the factual position on the ground in the foreign country as the driver of meaning. Second, it's very difficult to see how that assumption works. Its core is that if someone is in control of government functions, the only form of recognition that could have been intended would have been limited de jure recognition for the person the government had in fact recognised, and de facto for the rival that the government had not recognised and did not wish to recognise. So that would be very strange, we submit. And thirdly, it would be deeply unfortunate because it builds in as a basic premise that recognition must conform to control on the ground. Of course, no doubt it can do so, establish revolutionary government in Russia after the period of time, but that's not the same thing at all. We submit that constraint doesn't exist and is inconsistent with the approach in the House of Lords cases. And it's doubly unfortunate, it might be thought, in circumstances in which the principle suggested in the Court of Appeal's reasoning is that if you have a split de jure, de facto situation, and that is in play, the actions and authority of the de jure recognised person are in effect nullities, because the acts of the de facto government must be recognised by the courts. Of course, that principle Luther and Sagel built up when the Russian revolutionary government had come in. You just look at the de facto. But in our context, it leads to a very strange result indeed. The actual result will be not a one-voice principle, but as we put it in our case, a diametrically opposed voice principle, because you end up in the position where you're forced into making the choice. You have to have regard to the facts on the ground. You have to then say, therefore, that the person you don't want to recognise is in fact exercising authority. He's the de facto recognised person, because that's the only honest answer you can give. And by the way, you can then use that to say that the de jure recognised person can't do anything. So we respectfully submit it's intensely problematic for that reason. And the third difficulty with the Court of Appeal analysis, respectfully, is that the problems are compounded by seeking to explore and find facts about Her Majesty's government's involvement with the Maduro regime on the ground. That is, we respectfully submit, irrelevant to recognition. The correct focus is on the certificate and who we've chosen to recognise. In any event, it tells one absolutely nothing about the intention of Her Majesty's government in recognising, and that is because it is entirely possible for the government to recognise, take governments, say Government A, and then to have dealings, because they judge it in their best interest to do so, with another body running the relevant governmental functions in a particular area or part of that state. That was precisely the position that inured in relation to Somalia and Somaliland in CC. And the answer to it, I've given you it already, paragraph 130 in Lord Justice Lloyd Jones's judgment, was that it was for the executive to decide on the entities with which it will have dealings in the conduct of foreign relations. So you can choose to deal with, to use the Latin, the de facto authority in a particular area, because you have to do so. And one can think of any number of examples in which it would be thoroughly important that you should have that ability. For example, if you were trying to get someone back for trial on serious criminal charges and they'd fled to Somaliland or wherever it may be, you have to deal with the people you have to deal with. But that tells you nothing about recognition. And so that, we respectfully submit, goes nowhere. But we also would add that, and I don't develop this, but there's nothing inconsistent in any event between the recognition of Mr. Guaidó and the dealings, in fact, that have occurred, the limited dealings that have in fact occurred with the regime on the ground in Venezuela. See our case for that purpose at paragraphs 62 to 64. And perhaps more fundamentally and finally on this aspect, the base question is not whether the government has made the correct choice. The question is whether it has made a choice. And here, for all of the reasons that I've given, including selecting one out of a field of two, it plainly has. My Lord, that was what I wanted to say about recognition. I'm sorry if that's been a lengthy diversion into almost irrelevant territory, but given the difficulties with the Court of Appeal's reasoning, and given that you may at least decide that it's appropriate to say something, I hope that's been helpful. What I might do, if I'm allowed, is to take the short adjournment very briefly to reflect on whether I want to say anything about foreign act of state, and if I do, to have 10 minutes, if that's not too provocative, after 2 o'clock.
Yes, we'll adjourn now in that case and resume at 2 o'clock.
I'm very grateful.